14 months before a county judge asked, in open court and without particular warmth, who had actually signed the deed transferring Lot 47 of the Aldermore subdivision, a woman in a red blazer knocked on my front door and told me, with the patient condescension of someone who had delivered the same message many times before and never been seriously contradicted, that I did not own the parcel of land I had purchased, surveyed, insured, and paid property taxes on for the better part of 2 years. Her name was Constance Aldover, and she had served as the Aldermore Residential Covenant Board's Director of Property Standards for 11 years, long enough to have developed a precise and unarticulate contempt for the paperwork of people she considered smaller than herself. She was 51, blonde, and dressed with the kind of institutional care that signals a person who understands that appearance is its own authority. I told her, quietly and without opening the screen door more than a hand's width, that I had the deed, the survey, the title insurance commitment, and every tax receipt going back to the date of closing. She smiled at that and said the board's position was that the deed was procedurally defective, that the transaction had never been properly ratified, and that the lot in question, 47, had already been reclassified as common area buffer space under a resolution the board passed the previous autumn. I asked, plainly, when that resolution had been noticed to me as owner of record. She told me the board was not required to provide individual notice where a general posting had been made. I did not argue. I took a photograph of her standing at my door, noted the time as 11:43 in the morning, and went inside to call my attorney. Stay with this story to its end, because the deed Constance Aldover called defective turned out to contain a name she had not looked at closely enough, and that name changed everything that came after. My name is Rhea, and I had owned property before, though nothing with the particular complications that attach to a lot in a covenant-governed subdivision where the board has decided, quietly and without consulting you, that your land is more useful to them than it is to you. I was 32 when I closed on Lot 47, and I had spent the 3 years before that working as a municipal records analyst for the county assessor's office, which meant I understood, at a level of practical granularity that most people who buy residential lots do not, exactly what a valid conveyance looks like, and exactly what can render one voidable. I had left that job 8 months before the closing, not because I had grown tired of it, but because my father, Aldo, had died and left me a modest inheritance that made it possible, for the first time, to do the thing I had planned for most of my adult life: buy a piece of ground, build a small house on it, and stay there. Lot 47 was a rectangular parcel of 4,600 square feet at the eastern edge of the Aldermore subdivision, bordered on its north side by a 6-foot cedar fence belonging to the lot above it, on its south side by a gravel access strip, and on its east side by a drainage easement that ran the length of the block. The lot had been on the market for 14 months before I bought it, which was long enough that the listing agent had begun pricing it as though it were difficult, even though the title was clean and the survey was straightforward. I paid $89,400 for it, cash, in October of the year before Constance Aldover came to my door. I had already pulled permits for a foundation. I had already had the soil tested. I had already met twice with a structural engineer, whose name was Gerald Foss, and who had staked the corners of the proposed footprint on a Tuesday morning while a light rain moved through, and I stood at the edge of the gravel strip in a waterproof jacket and watched him drive the stakes, with the quiet satisfaction of someone who has waited a long time for a particular morning to arrive. The closing had been handled by a title company called Meridian Settlement Services, and the deed had been prepared by their in-house counsel and recorded with the county clerk's office on the 14th of October in the early afternoon, and the recording stamp on my copy read 4:37 p.m., which I knew because I had checked it the same day it came back to me in the mail, the way I check every document that carries my name. Constance Aldover had come to my door 7 months after that recording, and she had come, as I would later learn, not because the board had recently decided to reclassify Lot 47, but because the reclassification had been voted on and minuted and quietly backdated to a meeting held 3 weeks before my closing date, which meant that the board had known about the transaction, had chosen not to disclose their claimed interest, and had signed off on the common area reclassification anyway, with the apparent confidence that no one would check the meeting dates against the title chain. Gerald Foss was still driving stakes along the eastern edge of the lot when the first certified letter arrived from the board's attorney, a man named Douglas Pretch, who worked out of a commercial suite on the 3rd floor of a building that also housed an insurance brokerage and a tax preparation franchise. Pretch's letter ran to 4 pages and deployed the phrase procedurally defective 8 times in those 4 pages, as though repetition were a legal argument, and it closed with a demand that I cease all site preparation activity on Lot 47 immediately and acknowledge, in writing within 30 days, that the board's reclassification resolution held priority over my recorded deed. I read the letter twice, measured each of its 8 uses of the phrase procedurally defective against what I knew about the actual procedure, and then I called my attorney, a woman named Sandra Allett, who had practiced real estate law in the county for 22 years and who described Pretch's letter, when I read it to her over the phone, as creative and not much else. Sandra told me to stop no site work, to document everything I did on the lot going forward, and to send her the deed, the survey, the title commitment, and every piece of correspondence from the board and its counsel within the week. I sent it all that afternoon. She called me back the following morning and asked me whether I had noticed the name of the grantor on the deed. I told her I had, because I had read the deed carefully at closing and had noted that the grantor was listed not as the previous individual owner, whose name was Patterson Guel, and who had inherited the lot from his uncle 4 years earlier, but as the Aldermore Residential Covenant Board itself, acting in its capacity as administrator of an estate conveyance under a power of attorney arrangement Patterson Guel had signed before moving out of state. Sandra paused for a long moment after I said that, and then told me that if the board had executed the deed as grantor, it was going to be very difficult for the board to simultaneously argue that it had an unrecorded superior interest in the same parcel, because you cannot convey property and retain a competing claim to it without disclosing that claim at the moment of conveyance, and the deed disclosed nothing of the kind. I already knew that. I had known it the morning Constance Aldover stood at my door with her smile and her procedural confidence, and I had said nothing about it, because I had learned, in 3 years of working with county records, that the most useful thing you can do when someone is standing in the wreckage of their own position is to let them stay comfortable there a little while longer. The 30-day deadline Pretch had set came and went without a written acknowledgement from me. 3 days after it expired, Gerald Foss finished the stake survey, filed his report, and told me the footprint was exactly as planned. Sandra Allett filed a declaratory judgment action in the county circuit court on the 43rd day after Pretch's first letter, naming the Aldermore Residential Covenant Board as the sole respondent, and asking the court to confirm that my deed was valid, that the board's reclassification resolution was void, as applied to a parcel the board had already conveyed by arm's-length sale, and that any further interference with my permitted site work constituted an unlawful cloud on title. Pretch filed a response within 2 weeks, attaching as exhibits the minutes of the autumn meeting at which the reclassification had allegedly been voted on, and a certification signed by Constance Aldover, attesting that the minutes were accurate and complete. Sandra read the response that evening and called me the next morning to tell me that the certification was dated 4 months after the meeting it certified, which was not itself dispositive, but which, combined with the grantor problem, gave us something to work with. I asked her what she needed from me. She told me she needed the original deed, the recording receipt, and any communication I had received from the board or its counsel prior to my closing. on the theory that if the board had known about the sale and had not disclosed its claimed interest then, the non-disclosure was relevant to whether the reclassification had ever been a good faith exercise of the board's authority. I did not have any pre-closing communications from the board, because the board had not contacted me before the closing. But I did have something that Sandra had not yet seen, which was a copy of the board's own annual newsletter from the September before my October closing, a newsletter that had been mailed to all Aldermore residents of record, and that I had received as the then purchaser under contract, because the title company had added my address to the distribution list during the due diligence period. That newsletter contained a brief item, 3 sentences long, in which the board reported that Lot 47, quote, remained under active disposition review and would be addressed at the board's next regular meeting. Sandra was quiet for almost a full minute when I read her those 3 sentences. Then she asked me whether I still had the original mailed copy, with the postal indicia intact. I told her I did, because I kept everything, and I had filed the newsletter the same week I received it, under a folder I had labeled Aldermore General, which sat in a document box in the closet of the rental apartment where I was living, while I waited to build on my lot. She told me to bring it to her office the next morning and not to scan it or photocopy it before she had seen the original, because the postmark was going to matter. The postmark read September the 19th. The board's resolution reclassifying Lot 47 as common area buffer space was minuted as having been adopted on September the 22nd. The deed conveying the same lot to me was executed and recorded on October the 14th. What this sequence meant, when you laid it against the newsletter item, was that the board had publicly described Lot 47 as under active disposition review on the 19th, had voted on the 22nd to reclassify it, and had then proceeded to execute and deliver a deed of conveyance on the 14th of the following month, without disclosing to the buyer, to the title company, or to the county recorder that any reclassification had been voted on. Sandra sat across from me in her office and said, without any particular elevation in her voice, that this was not a paperwork problem. She had already subpoenaed the board's meeting minutes for the 18 months preceding my closing, and when those minutes arrived, delivered by the board's property manager under protest, and with a cover letter from Pretch warning that certain items were protected by deliberative privilege, they contained a gap. The minutes for the September 22nd meeting were present, and they included the reclassification resolution with appropriate motion language and 3 recorded votes. But there was no record of the vote that had authorized the board to execute the deed on Patterson Gule's behalf under the power of attorney. The power of attorney itself, a document that should have been recorded in the county land records before any deed it authorized could be lawfully executed, was not in the recorder's index. Sandra pulled the index herself, by hand, going back 4 years, and it was not there. That was the moment the shape of the thing changed. What had looked, from Constance Aldover's side, like a routine boundary dispute between a board with procedural authority and a property owner who might not know enough to fight it, had turned into something else entirely, because you cannot execute a deed as attorney-in-fact for a grantor without a recorded power of attorney. And if the power of attorney had never been recorded, then the board had no authority to execute the deed at all, which meant the deed had not been defective in the way Constance Aldover had claimed. It had been defective in a way that exposed the board, not me. Sandra filed a supplemental brief on a Thursday morning, attaching certified copies of the recorder's index search showing the absence of the power of attorney, a certified copy of the newsletter with its postmark, and a timeline she had prepared identifying every date on which the board had taken or omitted an action relevant to the conveyance. Pretch responded the following Tuesday with a motion arguing that the supplemental brief raised issues beyond the scope of the declaratory action and should be stricken. The judge, a woman named Honorable Celeste Drummond, who had been on the county bench for 17 years, denied the motion from the bench without written opinion, and scheduled a status conference for the following month. 3 days before that conference, a woman named Nora Cashel contacted Sandra by email. Nora Cashel had served as the board's recording secretary for 6 years before resigning the previous spring, and her email was brief and precise. She had kept personal copies of all board minutes during her tenure as a matter of professional habit, and she believed her copies of the September minutes differed, in at least one material respect, from the copies the board had produced in response to the subpoena. Sandra called her the same afternoon and arranged to meet her at Sandra's office 2 days later, the day before the status conference. Nora Cashel was 63, recently retired from a career in municipal administration, and she arrived with a binder. The binder contained her personal copies of the September 22nd minutes, printed from a draft she had emailed to herself before the final version was circulated to the board for approval. The draft showed the reclassification resolution as having been tabled at the September meeting, not adopted. The motion had been made and seconded and then tabled pending a title review that the board's own counsel had recommended before any reclassification affecting a parcel under active sale contract could be finalized. The title review had apparently never happened. The final version of the minutes, the version produced in response to the subpoena, showed the resolution as adopted on the same date that Nora's draft showed it tabled. Someone, between the draft and the final, had changed the outcome of the vote. The status conference became, within 4 working days of Nora Cashel's arrival at Sandra's office, a full evidentiary hearing. And Judge Drummond set it for a morning 6 weeks out and told both parties to bring their witnesses. The hearing ran for 2 days. Sandra called Gerald Foss, who testified about the stake survey and the permitted footprint, and the timeline of site work I had commenced in reliance on a deed I had every reason to believe was valid. She called the county recorder's deputy, a careful man named Herbert Vane, who confirmed under oath that no power of attorney from Patterson-Gule to the board, nor any variant of such a document, appeared anywhere in the county's recorded land records for the preceding 7 years. She called Nora Cashel, who produced her binder, walked the court through the differences between the draft and the final minutes, and explained that she had retained the draft because she had learned, in 6 years of serving as a recording secretary, that minutes sometimes changed between draft and final in ways that were consequential and not always deliberate, and she had never felt comfortable being the person whose signature confirmed accuracy unless she had a private copy to verify against. Constance Aldover testified on the second day, called by Pretsch, and she maintained under direct examination that the reclassification had been properly adopted and that the deed had been executed under authority the board held as a matter of long-standing practice rather than a recorded instrument. Sandra's cross-examination was 40 minutes long and moved with the patience of someone who already knew every answer. She asked Constance Aldover, in sequence, to identify the recorded power of attorney by instrument number, to explain why the newsletter had described the lot as under active disposition review 3 days before the vote she claimed had reclassified it, to account for the differences between the draft and final minutes, and to name the board member who had made the motion to adopt the reclassification at the September meeting. Constance Aldover answered the first question by saying she believed the power of attorney was on file somewhere, but she could not give a number. She answered the second by saying the newsletter item had been written in advance and referred to a different meeting. She answered the third by saying she was not the recording secretary and could not speak to the drafting process. She could not, when asked, name the board member who had made the motion. Judge Drummond asked one question herself, at the close of the second day, directed at Pretsch rather than at any witness, who had signed the deed on behalf of the board, and under what documented authority. Pretsch said he would need to consult his client. Judge Drummond told him he had until 9 o'clock the following morning. Judge Drummond issued her written order 11 days after the hearing closed. The order ran to 19 pages, and was careful in a way that suggested she had written it knowing it would be read again, somewhere, by people with interests in what it said. She found that the board had lacked authority to execute the deed because no recorded power of attorney existed and none had been produced, and that my title was therefore not derived from the board's conveyance authority, but was instead valid through a separate chain she identified in the title commitment, a chain that ran through the estate directly and that the title company's underwriters had insured without relying on the power of attorney as its basis. This was a line in the title commitment I had noted when I first received it, but had not fully understood until Sandra explained it to me the morning after the hearing, and it meant that my ownership was secure even under the worst reading of the deed's execution, because the title insurance had been written around a broader conveyance theory than Pretsch had accounted for. The order also found that the reclassification resolution as recorded in the final minutes could not be treated as operative, because the evidence established, by clear weight, that the motion had been tabled rather than adopted at the September meeting, and that the final minutes as produced to the court were materially inconsistent with contemporaneous records kept by the board's own recording secretary. The order voided the reclassification. It confirmed my title. It awarded me costs and attorney's fees against the board, itemized at $31,240, to be paid within 60 days. It directed the county recorder to annotate the board's authority documents with a notation of the court's findings, and to flag any future conveyance attempted by the board under an unrecorded instrument. Constance Aldover resigned from the board's directorship 9 days after the order was filed, in a letter that described her departure as voluntary and offered no other explanation. Douglas Pretsch closed his commercial suite the following spring and did not reopen it in the county. Nora Cashel, who had kept her binder out of professional habit and nothing else, received a letter of acknowledgement from the County Bar Association's Ethics Committee, which had taken an interest in the minutes discrepancy as a matter separate from my case. Gerald Foss broke ground on the foundation 3 weeks after the order, on a clear morning with a hard light coming off the gravel strip, and he worked with the same careful, unhurried pace that had characterized every hour he had spent on the lot, and by the end of that day, the outline of the house was visible in the earth. The newsletter, the one mailed in September with its postmark reading the 19th, I framed and hung it in the narrow hallway of the house once the walls were up, not as a trophy of the dispute, but as a reminder of what it cost to keep everything and what it costs not to. The board reconstituted itself under new governance the following spring, with a revised set of bylaws that required any reclassification of a parcel under active sale contract to be disclosed in writing to every party of interest before the vote, and that required any deed executed by the board on behalf of a third party to be supported by a recorded instrument filed no fewer than 30 days before the deed's execution date. Patterson Guel reached by phone by Sandra during discovery and asked whether he had ever signed a power of attorney authorizing the board to sell his lot on his behalf, said that he had signed something several years ago that he had been told was a routine administrative authorization, and that he had never been informed it was being used to execute a deed, and that he had received no proceeds from the sale. That information was part of what went to the county's prosecutor in a referral Sandra filed simultaneously with the costs motion, and the referral, along with Judge Drummond's findings, resulted in a separate proceeding that was still ongoing when the house was finished, and whose outcome belonged to a different record. Leander was the structural engineer's apprentice who spent 3 days during the framing phase asking me, with an earnest curiosity I found both appropriate and pleasant, why I had kept every piece of paper the board had ever sent me before I even owned the lot. I told him, unhurried and without particular drama, that I had worked in county records long enough to know that the people who are certain no one will check are always the people who are most wrong about that. He wrote that down in the small notebook he carried, the way he wrote down dimensions and load calculations, as though it were a number he might need later. The ground where the stake survey had first been done, and where the reclassification notice had claimed there would be buffer space and common lawn, held, by the time the last of the framing was complete, the outline of a house that was exactly the size I had planned, on a lot whose title had been confirmed by a court and annotated in the recorder's index and insured against any further claim arising from the same chain of events. What the board had assumed when it moved to reclassify the lot it had already sold was that silence is the same as ignorance, and that a woman who does not argue has nothing to argue with. Documents are patient in a way that confidence never is, and they outlast every assumption made by the people who believe they will never be read. That assumption had governed the board's conduct not only in my case, but, as the county prosecutor's office discovered during the separate proceeding, in 4 prior cases spanning 9 years, each one involving a parcel that the board had reclassified, encumbered, or quietly absorbed while its owner was either absent, uninformed, or simply unwilling to spend the money on an attorney who would read the minutes with the same attention the board counted on nobody applying. The earliest of those cases dated to a sale that had occurred before Constance Aldover's tenure, which told the prosecutor something about institutional culture that it told me too, which was that the practice had not begun with her, only been refined. She had inherited a method and improved its confidence, and the improvement had consisted almost entirely of finding owners who seemed unlikely to keep records and unlikely to know what the records would show if kept. The prosecutor's referral expanded into a formal investigation that named 3 current and 2 former board members in addition to Constance Aldover, and the charges, when they were filed in the spring of the following year, included forgery of a public document, fraudulent conveyance, and breach of fiduciary duty, the last of these applying to the board's obligations to the subdivision's residents, who had been paying assessments into a common fund that the board had used, in part, to pay Douglas Pretch's fees in disputes the board had manufactured and the residents had never been told about. The homeowners of Aldermore received notification of the investigation by certified mail on a Tuesday morning, and Sandra told me afterward that her office had fielded 11 calls from Aldermore residents in the 48 hours following the mailing, each of them asking some version of the same question, whether the reclassification process had ever been applied to their lot, and whether they needed to check. The answer, in 3 of those 11 cases, was yes, and in one of those 3 cases, a man named Vincent Aberley, who had owned a corner lot on the subdivision's western edge for 6 years, the encumbrance had already affected his ability to refinance, because the cloud on his title had appeared in a lender's search, and had caused his application to be held without his being told why. Sandra took his case the same week. The total acreage of parcels affected by the board's reclassification practice, when the prosecutor's investigators completed their audit of the land records, was just over 2 acres, distributed across 6 lots, held by 5 separate owners, none of whom had received the disclosure that any one of them would have been entitled to demand if they had known to demand it. Constance Aldover's resignation letter had described her departure as voluntary, but the investigation made that description difficult to sustain across any extended period of scrutiny. When the prosecutor's office obtained her personal email records under a court order issued in connection with the forgery charge, the records showed a message she had sent to Douglas Pretch the morning after Sandra filed the declaratory action, in which she wrote that the power of attorney had been a handshake arrangement they had all understood was sufficient, and that she had not thought anyone would go to the trouble of pulling the recorder's index by hand. Pretch had replied the same afternoon, advising her that he could not comment on matters that might be subject to privilege, which was a response that the prosecutor's investigator later described, in the dry vocabulary of an investigative summary, as consistent with counsel's awareness that the matter had grown beyond what a privilege assertion could usefully address. Those emails were entered into the prosecutor's file and became part of the record that the court would eventually consider in the sentencing phase, which was still months away when I moved into the finished house in early November. on a morning that arrived with a low sky and the smell of cut wood still faintly in the air from the final trim work the week before. I carried boxes from a rented truck with the help of 3 people. Gerald Foss, who appeared without being asked and worked with the same methodical care he applied to every physical task. Nora Cashel, who had driven 40 minutes because Sandra had mentioned in passing that I was moving in that weekend, and Nora had apparently decided that was sufficient reason to come. And Sandra herself, who arrived in work clothes and spent 2 hours moving boxes and refused, when I tried to thank her, to accept anything beyond the acknowledgement that the filing fees had been worth it. By noon, the 4 of us were sitting on the floor of the front room with the door open to the cold air and the gravel access strip visible beyond the cedar fence, and Foss remarked, without any particular ceremony, that it was a well-situated lot. Nobody disagreed. The criminal proceedings concluded the following March, 14 months after the initial referral. Constance Aldover entered a guilty plea to a single count of forgery of a public document and 1 count of fraudulent conveyance, in exchange for the dismissal of the remaining charges and a sentencing recommendation of 3 years probation, community service, and full restitution to all affected property owners, calculated by a forensic accountant at a total figure of $218,400, distributed across the 6 identified parcels in proportion to the documented harm each owner had suffered. Of the 2 other board members named in the original charges, 1 accepted a plea on reduced terms and 1 went to a full hearing, where the outcome was a finding of liability on the breach of fiduciary duty count and a civil judgment that would follow him for years. Douglas Pretch surrendered his law license in a consent agreement with the state bar in February, 4 weeks before the criminal plea, and the consent agreement's findings included a conclusion that he had assisted in the preparation of documents he had reason to know misrepresented the board's authority, which was the bar's careful way of saying what the prosecutor's file said more plainly. Herbert Vane, the county recorder's deputy whose index search had been among the first pieces of evidence to demonstrate what was missing, submitted a memorandum to his office's director, recommending that the county adopt a requirement that any deed executed under a power of attorney include a cross-reference to the recorded power of attorney's instrument number, with rejection of any deed lacking such a reference as a matter of routine intake procedure, rather than a matter left to individual examiner discretion. The director adopted the recommendation in modified form, effective the following fiscal year, and the modified version of the policy was broader than Vane's original proposal, applying not only to powers of attorney, but to any deed executed by an entity in a representative capacity. Nora Cashel, when she learned of the policy change from Sandra, sent me a text message that consisted of the word good and nothing else, which was, I thought, exactly the right length. Vincent Aberley refinanced successfully the following spring, once the cloud on his title had been lifted by a recorder's notation referencing the court's order and the prosecutor's findings. He sent me a note, handwritten on plain paper, that said he had not known what was happening to his loan application for 4 months and had assumed it was a problem with his credit history, and that learning the actual cause had been, in his word, clarifying. I kept the note in the same document box where the Aldermore newsletter still lived, no longer filed under Aldermore General but under a tab I had labeled Finished, because it was. Patterson Guel, who had signed what he believed was an administrative authorization and had received nothing for the sale of his lot, was included in the restitution order as a person whose interest had been used without adequate disclosure, and the figure assigned to him reflected the full sale price of $89,400, less the cost the board had legitimately incurred in administering the estate conveyance, a net figure that the forensic accountant calculated at $72,000, and that the board's bonding insurer paid within the 60-day window set by the restitution order. He called Sandra's office the week the payment cleared and asked her to pass along his thanks to whoever had kept the newsletter. She passed it along. The house on Lot 47 was, by the time the last of the legal proceedings concluded, a house I had lived in for 2 winters, with a garden along the gravel strip's edge that I had planted the first spring, and that was beginning, by the second spring, to look as though it had always been there. The cedar fence to the north had weathered to a gray that matched the sky on the mornings I liked best, and the drainage easement on the east side had filled in the previous autumn with a low grass that moved in the wind off the ridge, and that I had not planted and did not intend to cut. The stake Gerald Foss had driven on the southeast corner on a rainy Tuesday morning years before was still in the ground, painted orange at the top and barely visible above the grass line, and I had left it there deliberately. Not every reminder needs a frame. The people who assume that what you have not said is the same as what you do not know are always, in the end, defeated by what you kept.